Overview. There are contracts which are sometimes vague or has no clear meaning on either or both parties. Hence, interpretation of contract is critical as the duties and responsibilities as well as the right parties depend on how the contract is interpreted. As a general rule, the intention of the parties always prevail. However, in case of doubts, the provision of law should be used as a guide. This module will detail the different consideration to look at the interpreting the contract. Provision of law governing interpretation of contracts are also discussed so that you will be knowledgeable on applicable law in interpreting what is meant by the stipulation in the contract.
Learning objectives. At the end of this lesson, students are expected to learn how to interpret contracts, identify the different consideration in interpreting the contract, learn the applicable provision of law governing interpretation of contracts, decide on case involving interpretation of contracts. This module will discuss the following topics on how to interpret contract and what are the governing laws in interpretation of contracts.
Interpretation of a contract is the determination of the meaning of the term or words used by parties in their contract. It is the act of making intelligible that was not before understood, ambiguous or not obvious. If there is doubt as to meaning of a contract, the intention must prevail over the words that appear in the instrument of a contract. In other words, this article dictates how court should interpret ambiguous contract language and resolve dispute that may arise from it, so that both parties know exactly what they are agreeing to. Article 1373. If some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. Illustrate example. Esdra sold his racehorse named Makibao. Incidentally, there are two horses with the name Makibao. However, one of them is amputated. Legal opinion. In this case, it is clear that the intention of Esdra for buying a racehorse is to be used for racing competition. Hence, though there are two race horses with the same name, the one only which is not amputated should be the object of the contract to fulfill its purpose.
Article 1374. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taking jointly. Here are the illustrative example. Ezra leases house to Homer. Ezra forbid Homer from subleasing the property without his consent. Further, it was stipulated that if Homer subleased the property to a third person, there will be additional 1,000 pesos per month payment on top of his rent. Legal opinion. In this case, the interpretation of the additional 1,000 pesos per month payment on top of his rent will serve penalty for non-compliance of the provisions of the contract and not just an additional payment. So it means that a contract must be interpreted as a whole. and the intention of the parties is to be gathered from the entire instrument and not from particular words, phrases, or clauses. All provisions should, if possible, be so interpreted as to harmonize with each other's. All contracts involve exchanging something that has some value, be it a product, service, or money. Each of the contracting parties has some responsibilities with respect to this exchange. These responsibilities are known as contract obligations. If any of the parties fails to fulfill its obligations, it's almost to a breaching party to reimburse the other party for the damages. Consideration of the mutual promise of the parties forms from the basis of a contract. These promises define the scope of rights and obligations of the contracting parties. If one party fulfills its obligations under the contract, while the other party fails to do so, the fulfilling party can approach a court for seeking relief. Usually, courts to grant monetary damages for the breach of a contract. However, in some special cases, courts may also ask the breaching party to fulfill its contractual obligations. Since contracts are legally enforceable, the contracting parties can use contracts as a basis of their business relationships. Conflicting provisions of contract as statutes. The provisions of a contract should not be read in isolation from the rest of the instrument, but on the contrary, interpreted in the light of other related provisions. It is a canon of statutory construction that the whole and every part of the statute must be considered in fixing the meaning of any of its parts, and in order to produce a harmonious whole. This is also the injunction in Article 1374. Contract contained in several documents or in two or more separate writing, all of them must be taken together to determine the intention of the parties. Business, forms, order, slip, delivery charge, invoice, and the like, which are issued by the seller in the ordinary course of business, are not always fully accomplished to contain all the necessary information describing in detail the whole business transaction. In most cases, the sale clerk merely indicates a description and the price of each item sold without bothering to fill up all the available spaces in the receipt or invoice. More often than not, they are accomplished perfunctorily without proper regard to any legal repercussion for such neglect, despite their being often incomplete. Said business forms are commonly recognized in ordinary commercial transactions as valid between the parties, and at the very least, they serve as acknowledgement that a business transaction has in fact transpired. Oftentimes, these forms are issued by laymen who, not fully appreciating their legal signification, prepare them in a slipshod manner. The titles given to section of a contract may be resorted to for the purpose of determining the scope of the provisions and their relations to other portions thereof, but to separate sections or articles of a contract cannot be correlated with each other, where the parties have expressly provided for a separability clause, that one article cannot have a restrictive effect upon the meaning of another article.
Article 1375. Words which may have different signification shall be understood in that which is most in keeping with the nature and object of the contract. This is the illustrative example. Erza leased to Homer a roof for the purpose of erecting an advertising sign. The contract provides for the termination of the lease by Homer if a building should be constructed on an adjoining property of such height as to obscure the view of Homer's signs. There was erected on the roof of an adjoining building a sign which obstructed the view of Homer's sign. Legal opinion. In this case, the interpretation of the word building here should be interpreted as not the literal building, but any structure that obscured the view of Homer's sign. Hence, the construction of the sign which obstructed the view of Homer's sign will be valid reason for the termination of his contract of lease with ERSA. In Section 1, except as herein otherwise provided, there shall be assessed, collected, and paid a special excise tax of 17% on the value in the Philippine peso of foreign exchange, sold and or authorized to be sold by the Central Bank of the Philippines or any of its agents until June 30, 1956. In Section 2, the tax provided for in Section 1 of this Act shall not be collected on foreign exchange used for payment of the cost, transportation, and other charges incident to importation in the Philippines of canned milk, canned beef, cattle, canned fish, cocoa beans, malt, stabilizer and flavors, vitamin concentrate, supplies and equipment purchased directly by the government of or any of its instrumentalities for its own exclusive use, machinery, equipment, accessories, and spare parts for the use of industries, miners, mining enterprises, planters and farmers, and fertilizers when imported by planters or farmers directly or through their cooperatives, articles or container use, including materials for the manufacture of tin containers used by the importer himself, in the manufacture or preparation of local products for consignment or export abroad. Textbooks, reference books, and supplementary readers approved by the Board on Textbooks and established public or private education institutions. Paper improved by publisher for their exclusive use in the publication of books, pamphlets, magazines and newspapers, carbines, explosive and dynamite for mining purposes, drugs and medicine and medical and hospital supplies listed in the appendix of this act. Payment in respect of the insurance, payment in respect of marine and aviation insurance, spare parts to be used in the repair of vessels of the Philippine Registry or airplanes and such other parts thereof as may be certified by the Hulls and Boilers Division of the Bureau of Customs or the Civil Aeronautics Administration, respectively, as essential to the maintenance of vessels or airplanes. Payments of purchase price of vessels or ship of any kind or nature intended for Philippine registry. 90% of the ownership of which belongs exclusively to Filipinos, or charter fees of airplanes and vessels of the Philippine Register, remittance by airlines of American Registry operation between the Philippines and the United States of income in the Philippines to their head office the United States, provided that such airlines have been granted a permit to operate under the Air Transport Agreement between the United States and the Philippines prior to the enactment of Republic Act Number 601, remittance of payment of principal and interest of foreign loan contracted under the obligation of the Philippine government or any of its instrumentalities, remittance for payments of living expenses of students pursuing courses of the study abroad not exceeding the equivalent of $250 per month, including payment of tuition, books, medical expenses, and other school fees, and dollar allocation for one trip a year and not exceeding $300 for each Filipino pilgrim of religion traveling abroad under permit of the government, payment of premiums by veterans on life insurance policies under the government of the United States, the payment of premiums and other amounts due by policyholders on life insurance policies issued before December 9, 1949, and payments of machinery and raw materials to be used by new and necessary industries are determined in accordance with Republic Act Number 35 as amended by Republic Number 901. Article 1376. The usage or customs of the place shall be borne in mind in the interpretation of the ambiguities of a contract, and shall fill the omission of stipulation which are ordinarily established. This article explains the effect of usage or custom of the place. It is necessary to know if the contract was entered into may be received to explain the theory to parties in the contract with reference to such usage or custom. But if the custom is general in character, it is presumed to be known by the parties. Resort to usage or custom as aid in interpretation. The usage or custom of the place where the contract was entered into may be received to explain what is doubtful or ambiguous in a contract on the theory that the parties entered into their contract with reference to such usage or custom. Article 1376. Illustrative example. Job sold to Housey a horse. It was custom of the place to put a horseshoe on sold horses. Legal opinion. In this case, even if it was not mentioned in the contract that shoe horse must be included in the sale of horse, Job has to put a horseshoe to the horse to be delivered as this is the custom in their place.
Article 1377 is that a party who dropped the contract more easily than the other could have prevented mistakes or ambiguity in meaning by careful choice of words or by the exercise of little more care. Article 1378. When it is absolutely impossible to settle doubt by the rules established in the preceding article, and the doubt refers to incidental circumstances of a gratuitous contract, the list of transmission of rights and interests shall prevail. If the contract is one rules, the doubt shall be settled in favor of the greatest reciprocity of interest. If the doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties. The contract shall be null and void if one rules in favor of greatest reciprocity of interest. Illustrate example. It was not clear whether Neo or lent or donated to Adam a specific phone. Is the contract a commoditum or donation? Legal opinion. The contract is commoditum because in a gratuitous contract, the interpretation should be the least transmission of rights. Summary. Interpretation of a contract is the determination of the meaning of the terms or word used by the parties in their contract. If there is a doubt as the meaning of the contract, the intention must prevail over the words that appear in the instrument of the contract. Article 1370. Literal meaning is enough if the term in the contract is clear. Contract is void if the principal object cannot be ascertained. In judging the intention, subsequent acts of parties are considered.
Article 1378. When it is absolutely impossible to settle doubts by the rules established in the preceding articles, and the doubts refer to incidental circumstances of a gratuitous contract, the least transmission rights and interest should prevail. If the contract is onerous, the doubt should be settled in favor of the greatest reciprocity of interest. If the doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties, the contract should be null and void. Sinabing gratuitous contract, the doubt refer to incidental circumstances of a gratuitous contract. Such interpretation should be made which would result in the least transmissible of rights and interests. When despite the application of the preceding rules, articles 1370 to 1377, certain doubts still exist, such doubts should be resolved in accordance with the supplementary rules stated in the Article 1378.
Interpretation of contracts. So for me, interpretation of contracts mostly follow the rules of the handwritten terms, supersede pre-printed terms, but typewritten term. However, if the terms are written the same way and still conflict, the court looks to see if the conflicting terms are general or specific when interpreting something or conflicting specific clauses and finding no answers after the initial process. The courts always apply the fundamental principle that a contract should always be interpreted whole, not clause by clause and not section by section. If the contract as a whole does not supply resolution, the court starts to look outside the contract for answers. In Article 1371, it says that the literal meaning is enough if the terms in the contract is clear. Contemporaneous and subsequent acts shall be considered. Contract is void if the principal object cannot be ascertained. In judging the intention, subsequent acts of parties are considered. Here are my explanations in Article 1371. To interpret, the law is to tell what it means, assuming the contract is a binding legal instrument. It is subject to interpretation. Therefore, given a specific situation based on reality, not just theory, a court could tell what enforcement of the contract under the law would mean. In other words, the court could settle a dispute based in legal interpretation of the contract. If you have said contract, that meaning would be clear. In that case, you simply refer to the relevant contract law of the appropriate jurisdiction to decide how to construe the application of a contract. However, some contracts specify how certain terms are to be interpreted and how arbitration is to be conducted may be written into the contract if the parties agree to do so. Sometimes disagreements arise because of the failure to define the scope in sufficient detail to produce the desired result, because often one of the parties to the agreement fails to meet their obligations and seeks suspension through lying, theft, and intimidation. For example, Asen and his girlfriend Kathleen instituted head overseer in the land of Shanley and Shane, who will take care of their plans. Plaintiff Asen, with respect to defendants Shanley and Shane, plans will not share percentage for the land, but defendants have to plant coconut and the plaintiff will not pay as their condition. Parties entered into another agreement concerning the condition given in copra making is 1/3 defendant hold plaintiff, telling him not to interfere with the plans as they had no agreement yet for the year, and that being the landowner, he should be the one to decide in accordance with the Nancy law. So the defendant sent another letter to plaintiff prohibiting him from planting and clearing the land for the same reason. Plaintiff sought the assistance of the Office of the Agrarian Council. Plaintiff brought an action against defendant into the Court of Agrarian Relations, praying that defendant be held guilty of illegal ejectment, that in view of the strained relationship with defendant, he was waiving his right to reinstatement provided he be paid reasonable compensation for his improvements, and that defendant be ordered to pay him actual and moral damage. Judge was rendered dismissing the suit for lack of merit. Plaintiff appealed to the Court of Appeals, which court, however, certified that case to us. The question is, was the plaintiff instituted as an overseer or as a tenant by defendant? It is clear that the plaintiff was made an overseer of defendant, not a tenant. No tenancy relationship had ever existed between the parties. What transpired was that plaintiff was made overseer over a take-care land area. He was to supervise applications for loans from those residing therein. He was allowed to build his house thereon and to plant specified plants without being compensated. He was free to clear and plant the land as long as he wished. He had no sharing arrangement between him and defendant, and he was not obligated to pay any price certain to nor share the produce with the latter.